Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, we finally got some decisions from Judge Messer today in the case of Adam Montgomery. The biggest one being, remember his team requested that the two cases be severed and he have two different trials. She denied that particular request, which that was, honestly, I am thrilled because the assault and the second degree murder needs to be together as one. There's no reason for them to be separated whatsoever. And I'm going to actually go over the documents as well here. But Judge Messer also ruled that the jury can see a video from a September 2021 encounter between Adam and police in which officers question him about Harmony's whereabouts, but they cannot play the audio because of his right to remain silent. And we've gone over that video here on the channel, so as always, you can look back at the my Harmony Montomgery playlist on the channel. And the court also said that prosecutors can only introduce evidence relating to alleged domestic violence against Adam Montgomery's estranged wife, Kayla Montgomery, from between December 2019 and January 2022. So nothing involving incidents prior to that date range can be admitted. Also, it was ruled that prosecutors can only discuss alleged neglect and abuse toward Harmony in that time frame as well. And also, it looks like she ruled that evidence of drug use can be introduced. Prosecutors argued that the drug use can lead to paranoia, and it would answer a lot of questions, including why the family became homeless. Of course, the state believes, they also believe that drug use is directly connected to the circumstances surrounding little Harmony's death. So those are the rulings in a nutshell. So I'm going to just go through them real quick, go through the documents here. Again, we are a go for February 6th for things to start off getting justice for little Harmony, for jury selection. And I could not be happier because this little sweet child right here, she deserves justice, and it is coming. It is coming very, very soon. So this is the document, the order she put out today on the defendant's motion to sever. So I'm going to kind of just sift through it. The defendant, Adam Montgomery, is charged with second-degree assault based on the defendant's alleged July 2019 assault of his then 5-year-old child, Harmony Montgomery. And they're going to just refer to her as Harmony going forward. In another docket, the defendant is charged with second-degree murder, tampering with witnesses and informants, falsifying physical evidence, as well as abuse of a corpse based on his alleged murder of Harmony on December 7th, 2019, and the resultant actions that the state alleges were taken to conceal the murder and dispose of her body. The defendant previously filed an assent to motion to join both cases, which the court granted. The defendant now seeks to revisit the joining of the two dockets and moves to sever the charges before trial. The state and the defendant subsequently exchanged responsive pleadings regarding the defendant's motion to sever. For the reasons that follow, the defendant's motion to sever is denied. And again, the rest of this stuff is very important as well that she ruled on today, that Judge Messer ruled on. But this whole keeping this case together, I was so happy to see that she's not putting up with that whatsoever. Here's the factual background. The following facts are derived from the parties' proffers in their pleadings, as well as the probable cause affidavits filed in support of both cases. On November 18th, 2021, Crystal Sever called the Manchester Police Department, MPD, to report her biological daughter missing. Sever told the MPD that she had not seen her daughter Harmony since approximately April 21st, 2019. At the time, the child was in the physical and legal custody of the defendant, her biological father, pursuant to a decision from the Lawrence Juvenile Court in Massachusetts on February 21st, 2019. Subsequently, an employee of the MPD contacted the Division for Children, Youth, and Families, DCYF, of the New Hampshire Department of Health and Services. MPD's initial attempts to check the previous addresses provided by DCYF proved unsuccessful. On December 27th, 2021, DCYF notified the MPD they were unable to locate Harmony. As a result, the MPD initiated an investigation into Harmony's whereabouts and actively attempted to track down the defendant. During their investigation, MPD officers and investigators made contact with members of the defendant's family. After speaking with the defendant's uncle, Kevin Montgomery, the MPD learned that the defendant had reportedly given Harmony a black eye in July 2019 and admitted the conduct to Kevin Montgomery when Kevin was at the Montgomery house. On December 28, 2021, a detective with the MPD spoke with Kayla Montgomery, the defendant's wife, and inquired about the last time that she had seen Harmony. Kayla indicated that she had last seen Harmony in November or December of 2019. She said she believed the defendant brought Harmony to Surrey around that time. Kayla told police she had not physically seen the defendant since late October 2021 and had not spoken with him since mid-November 2021. On December 31st, 2021, Kayla participated in a voluntary interview with MPD detectives and discussed in further detail the last day that she had seen Harmony. Also on December 31st, 2021, MPD patrol officers were on the lookout for the defendant and his then-girlfriend, Kelsey Small, in Manchester. Upon discovery of the defendant's whereabouts, detectives responded to the location to speak with the couple. At that time, the MPD determined that Harmony was not with the defendant and her whereabouts continued to be unknown to the police. So there's that footage that they're going to allow, but not the audio. Because DCYF was granted protective supervision of Harmony, the defendant was given an order that day instructing him to cooperate with the MPD and assist with locating Harmony. However, the defendant did not cooperate with police. Upon issuance of a warrant, the defendant was arrested and charged with second-degree assault for causing bodily harm to Harmony in July of 2019, as well as 1 count of interference with custody and 2 counts of endangering the welfare of a child. Subsequently, the MPD continued their investigation and search for Harmony. On May 20th, 2022, Kayla Montgomery testified under oath before the grand jury in Hillsborough County, Northern District, as part of the grand jury's investigation into Harmony's disappearance. After investigating Kayla's testimony to the grand jury, investigators discovered she made several untruthful statements while under oath. As a result, an arrest warrant was obtained and Kayla was arrested on 2 charges of perjury on June 3rd, 2022. On that same day, Kayla participated in a proffer interview at the Manchester Police Department. During the interview, Kayla revealed that Harmony had died on December 7th, 2019. Now, this arrest was when they went to this home. She was staying with this guy, and man, they went all out like SWAT, and they threw these guys on the floor, all out. Man, they were not nice to Kayla whatsoever. Kayla shared that they had become homeless in November of 2019 and that she lived with the defendant and their children in their vehicle. Kayla explained that the defendant would become upset that 5-year-old Harmony was not communicating when she needed to go to the bathroom and was having accidents in the car. Kayla indicated that after each accident, the defendant would strike Harmony in the face-head with a closed fist. She stated that the defendant struck Harmony multiple times after one of her accidents, which caused her death. This poor girl, all she had to do was go pee. And her father, well, this biological person that helped create her, I don't really want to call Adam a father, decides because she's asking to go to the bathroom, or she was afraid to ask to go to the bathroom on other occasions, he decided to beat the crap out of her, which ended up killing her. He is a monster, period, in my book. Monster. Over the succeeding months, law enforcement personnel continued their investigation to gather evidence and corroborate Kayla's account of Harmony's death. It's kind of hard to believe Kayla, but when she got this proffer, which it still really bothers me that she has this proffer. After reading the probable cause for Adam's charges of murdering Harmony, it bothers me so much that she has this proffer. In October of 2022, the defendant was charged with second-degree murder, tampering with witnesses and informants, falsifying physical evidence, and abuse of corpse. On November 23, 2022, the defendant filed an assented to motion to join the second-degree assault charge with the charges in the second case. The motion was subsequently granted and the cases were joined. So see, he wanted it all together because, see, Adam thinks he's hot crap. He's hot S-H-I-T. He don't care. He really does not care about anyone but Adam. So he's probably like, yeah, I don't care, throw them all together. On January 11th, 2024, members of the state met with Kayla in anticipation of trial. After that meeting, the state supplemented their previously provided discovery materials and sent the defense notice of 3 purported changes or additions to Kayla's account of the circumstances leading to Harmony's death in the form of a Zwicker letter. The instant motion followed. I'm going to link to Sleuth Mom. She went over this Zwicker letter. For those that are interested, I'm going to link to her live on that. She went into detail to explain that for those that would like to check that out. The analysis. In support of his motion, the defendant points to the Zwicker letter he received on January 11th, 2024, and argues that there has been a substantial change in evidence in the weeks before trial. The defendant argues that the state, quote, now portrays the second-degree assault and second-degree murder charges as mere parts of a larger, persuasive, and sustained pattern of abuse, unquote. Come on, Adam. It's been like that since the get-go, dude. We all know exactly who you are. The defendant contends that such a strategy will interfere with the jury's ability to, quote, impartially consider the charges separately on their own individual merits, unquote. You have no merits, first of all, Adam. And second of all, separated charges wouldn't do crap for you, dude. So, yeah. But, you had to try, I guess. You had to try. The extent to which, if at all, these new pieces of information, along with the other evidence in the case, would result in unfair prejudice to the defendant if the previously joined dockets remain together, quote, is a factor for the trial court to consider under the, quote, best interests of justice prong, unquote, of the jointer analysis. Accordingly, the court analyzes whether joinder is appropriate under the present circumstances of the cases. Pursuant to Rule 20 of the New Hampshire Rules of Criminal Procedure, if a defendant is charged with 2 or more related offenses, either party may move for joinder of such charges. The trial judge shall join the charges for trial unless the trial judge determines that joinder is not in the best interests of justice. In doing so, joinder seeks to, quote, achieve efficiency and economy for both the government and the defendant, unquote. So joint trials avoid the duplication of evidence and may reduce the inconvenience to victims and witnesses, and the potential benefits to the defendant may include the faster deposition of pending charges, the possibility of concurrent sentence in the event of conviction, and protection against enhanced sentencing that might occur from separate trials. Related offenses. The court must first determine whether offenses are related for purposes of Rule 20. It looks like offenses are related if they are alleged to have occurred during a single criminal episode. B, constitute parts of a common scheme or plan, or C, are alleged to have occurred during separate criminal episodes, but nonetheless are logically and factually connected in a manner that does not solely demonstrate that the accused has a propensity to engage in criminal conduct. As the state recognizes the absence of evidence indicating a single criminal episode or common scheme, requires the court's analysis to focus whether the offenses are logically and factually connected. This is largely determined by the close relationship among the offenses with respect to both the underlying charged conduct and the evidence to be used to prove the charges. The New Hampshire Supreme Court set forth 5 factors that trial courts should consider when determining whether charges resulting from separate criminal episodes are related. 1. The temporal and spatial relationship among the underlying charge acts. 2. The commonality of the victims and or participants for the charged offenses. 3. The similarity in the defendant's mode of operation. 4. The duplication of law regarding crimes charged. And 5. The duplication of witnesses, testimony, and other evidence related to the offenses. While no single factor is dispositive to the question of relatedness, these factors are, quote, guidelines that must be sensibly applied in accordance with the purposes of joinder, unquote. Here, the parties agree that the underlying events from which the charges arise lack a clear temporal and spatial relationship which weighs against joinder. However, the state argues that the remaining Brown factors support keeping the 2 cases joined. The court addresses each in turn. The state argues, and the defendant does not appear to dispute, that there is commonality between the 2 charges because the 2 cases involve a common defendant and victim. Okay, they go on to talk about the state versus Bruno here. The Supreme Court found the charged offenses were logically and factually related when they were involved with the same perpetrator and victim. Here, the defendant is the common perpetrator and Harmony is the common victim in the second-degree assault charge in the first case and the second-degree murder charge in the second case. Additionally, Kayla Montgomery is the central witness in both cases. This commonality between the 2 cases supports the relatedness of the charges. Mode of operation. The defendant argues that the mode of operation is dissimilar in each case because the alleged mode of operation, striking the victim with one's fist, differs in the degree of force and number of blows. In response, the state argues that the mode of operation in the 2 cases supports joinder because in each case, the defendant physically assaulted Harmony with his hands when he was angry with her. The court agrees with the state. The Supreme Court has found a consistent mode of operation supporting joinder when the defendant utilizes a similar means or method when committing the alleged offenses. In Gerard, the Supreme Court determined that the defendant's proficiency with technology enabled the defendant to take actions that underlay each of the charges. Likewise, in the Brown, the Supreme Court found the defendant's mode of operation was similar for all the charges because they involved a drug buy in the defendant's car. While the defendant's alleged conduct may differ in the degree of force and number of blows, the Supreme Court has focused on the underlying method utilized while committing the alleged offenses, which is the same in both matters. Thus, the mode of operation is sufficiently similar to weigh strongly in the favor of joinder. Duplication of law. The defendant argues that there is no duplication of law because the law the jury will be expected to apply differs in both mens rea and actus reus. In response, the state argues that the law of assault and murder have running through them the same core concepts. Bingo! The court argues with the defendant that the mens rea and the actus reus in the 2 matters differ. There is little overlap in the law to be applied in these cases to support joinder on the basis of this factor. However, while this factor weighs against joinder, the court does not find this factor to be particularly significant in the context of the pending charges here. The law to be applied on the charges is not particularly complex. The court does not find that this will create confusion amongst the jury or challenge their ability to apply the law to the facts as they find them. Therefore, while the court finds this factor weighs against joinder, it does not find the weight significant. duplication of witnesses, testimony, and other evidence. Lastly, the court must consider the duplication of witnesses, testimony, and other evidence, which is routinely an important factor and policy goal of joinder that contributes to the relatedness of offenses. While the defendant recognizes there will be some duplication in witnesses, he argues that the overlap is minimal when compared to the number of witnesses and evidence pertaining solely to the second-degree murder charge. He also points to Kayla Montgomery, who he argues will have relevant information to impart solely with respect to the second-degree assault, but not for the second-degree murder charge. In response, the state admits that the length and number of witnesses for each case would be different if severed. However, the state indicates it would rely on the same witnesses to establish Harmony's residence, the injury scene, the after effects of the defendant's criminal behavior, and the defendant's intimidation of others in his circle to prevent them from reporting or testifying to what they had witnessed, or as retribution from having done so. Notably, underlying both cases is testimony from law enforcement who investigated Harmony's disappearance, as well as the testimony of Kayla Montgomery, who is alleged to have directly bore witness to much of the defendant's alleged criminal acts. Similarly, both cases will inevitably involve lengthy and detailed cross-examination and impeachment evidence of Kayla Montgomery. Further, in light of second-degree assault charges being brought in connection with the police investigation of disappearance of Harmony, there would be significant duplication of evidence regarding preliminary matters as well. While the two cases lack a complete duplication in witnesses and testimony, the court finds significant duplication weighing strongly in favor of joinder. Okay, let's see here. For the aforementioned reasons, the court concludes that the underlying offenses are related and thus finds that the Brown factors weigh in favor of joinder. Best interest of justice. After considering the Brown relatedness factors, the court must evaluate whether joinder will offend the best interest of justice. The New Hampshire Supreme Court has articulated the best interest of justice standards as follows. Charges should be tried separately whenever it's deemed appropriate to promote a fair determination of the defendant's guilt or innocence, which includes evaluating whether, in view of the number of offenses charged and the complexity of the evidence offered, the trier of fact will be able to distinguish the evidence and apply the law intelligently to each offense. Joinder can give rise to other concerns of undue prejudice as well, which may cause the best interests of justice to override conducting a single trial, such as when charges may be likely to unusually inflame the jury against the defendant, or when a weak case is joined with a strong case. A defendant can be disadvantaged if the available defenses are inconsistent or if the defendant wants to testify as to one offense but not as to others. Ultimately, in determining the best interest of justice, the purposes underlying joinder, i.e. efficiency and economy, must give way when conducting a single trial would jeopardize a defendant's right to fair trial. Accordingly, the court now considers the defendant's argument that the state portrays the second-degree assault and second-degree murder charges as mere parts of a larger, persuasive, and sustained pattern of abuse. Specifically, the defendant argues that the state intends to employ a trial strategy of bootstrapping the separate offenses and portray a long and unrelenting pattern of abuse and neglect that defies a jury's ability to impartially consider the charges separate on their own individual merits. In support thereof, the defendant points to the Zwicker letter, which provided 3 asserted deviations from Kayla's original anticipated testimony, as discerned from Kayla's interview on January 11, 2024. Notably, the letter notifies the defendant of the following. 1. Kayla herself saw the defendant strike Harmony in the week prior to the family becoming homeless. 2. Kayla disclosed that she believed the defendant cut off contact with Crystal Surrey because he did not want her to discover he was bruising Harmony. And 3. Kayla now describes Harmony as skinny and looking exhausted at the time they were living homeless in their car. The court notes, however, that evidence of abuse is not necessarily inadmissible or unfairly prejudicial to the defendant. Rule 404 of the New Hampshire Rules of Evidence provides in pertinent part that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, planned knowledge, identity, or abuse of mistake or accident. Let's see. While the state has not noticed any intent to admit evidence under the Rule 404B, the Supreme Court has indicated other act evidence is intrinsic and therefore not subject to Rule 404B when the evidence of the other act and evidence of the crime charged are inextricably intertwined, or both acts are part of a single criminal episode, or the other acts were necessary preliminaries to the crime charged. Typically, such evidence is a prelude to the charged offense, is directly prohibitive of the charged offense, arises from the same events as a charged offense, forms an integral part of a witness's testimony, or completes the story of the charged offense. Against this backdrop, the first and third deviations in Kayla's anticipated testimony may be properly admissible as intrinsic evidence of other acts. Otherwise, the state indicates that it has no intention of raising the second deviation regarding Kayla's opinions about why the defendant cut off contact with Sever, in this case in chief. Given the state of the evidence at this time, including the information in the January 11, 2024 Zwicker letter, and taking into account the court's ruling on the defendant's motion to exclude Rule 404B evidence, the court is unpersuaded that the second-degree assault and second-degree murder charges, when tried in the same case, prevent a jury from impartially considering the charges. Notably, the lack of any Rule 404B evidence in the period between the alleged second-degree assault in July of 2019 and directly preceding the alleged second-degree murder in December of 2019 would allow a jury to discreetly consider the two charges. Further, the underlying charges and the evidence supporting them are not so complex as to raise concerns that a jury cannot intelligently apply the law and relevant facts to each charge. Any remaining concern that the jury will convict a defendant upon the accumulated effect of the evidence is appropriately quelled through carefully crafted jury instructions. Ultimately, both the state and the defense can benefit from joinder in this circumstance. Joinder enables the state to avoid the duplication of evidence required by separate trials, to reduce the inconvenience to victims and witnesses, to minimize time required to dispose of the offenses, and to achieve a variety of other economies in connection with prosecutorial and judicial resources. Likewise, when charges are joined into a single trial, the defendant may raise reasonable doubt as to his responsibility for one of the charges, and that doubt might undermine the strength of the state's case as to all other charges. Additionally, if the defendant successfully impeaches the credibility of a witness in one instance, such impeachment will affect the credibility of the witness in regard to their testimony as to all offenses. Here, the recent deviations in Kayla Montgomery's intended testimony, as indicated in the Zwicker letter, provide additional opportunity for the defendant to seek to impeach her credibility, but does not support severance. Therefore, the court finds that the jury will be able to distinguish the evidence and apply the law intelligently to each offense without jeopardizing the defendant's right to a fair trial, and the best interests of justice are served by consolidation. Conclusion. For the foregoing reasons, the court determines that the charges in the two dockets are sufficiently related and comport with the best interest of justice. Accordingly, the state motion to sever the two dockets is denied. And it was signed, of course, by presiding Justice Amy B. Messer. That was a lot of reading. 14 pages. So that is her main explanation. Yeah, I did skip over some of the referencing the law, but if you want to look into that, I will link to the court documents here so you guys can check them out on your own. All right, and this one here, which was also filed today on the 25th, is the omnibus order on pending motions in limine. I'm not going to go through this entire one because it's, as you can see, it's 15 pages, so I'm going to link to it. It's going to kind of sift through it here. Defendant's motion in limine to preclude the state from introducing evidence of the defendant's encounter with law enforcement on the morning of December 31st, 2021. So this one's talking about the video when they knocked on his car window and they were asking about Harmony, which, as we saw, the judge is allowing the video but not the audio. So the state wanted the entire thing in, obviously, and the defendant wanted it all to be thrown in the trash. So she decided to show the video, and I think body language is huge, but the audio will be muted. And then we have part 2 is defendant's motion in limine, allegations of prior or subsequent bad acts of the defendant. Again, that was where she limited the dates. So she kind of granted part of it and then she denied the other part. So that's also in here. So yeah, this is pretty much just going through all of their motions in limine. So I'm going to definitely include this. So if you guys want to read the whole thing, please do. Part 3 is defendant's motion in limine to admit impeachment evidence regarding Kayla Montgomery. And of course, the defendant's motion is granted. So they kind of won this one. They eliminated some of her dates and other things, like we saw, were granted. But we can't trust Kayla completely, but, what are you going to do? She is the biggest witness, in the state's case. Then you got 4, and here the defendant's motion in limine to exclude evidence of Home Depot purchases. All right, let me go through this one a bit here. The defendant moves to exclude evidence of a February 15, 2020 purchase of pelletized limestone from the Home Depot in Hooksett, and a February 26, 2020 purchase of pelletized limestone, a metal cutting diamond blade, a fuel grinder, and a lithium-ion battery and charger from the Home Depot in Manchester. The defendant contends that the evidence is irrelevant because the identity of the purchaser is unknown. Evidence is relevant if it has any tendency to make a fact of consequence to the determination more or less probable that it would be without the evidence. Here there is a substantial circumstantial evidence that the defendant purchased the lime identified above and used it in the commission of the crimes charged. The state will introduce evidence that on February 26, 2020, a cash withdrawal was made from Kayla Montgomery's bank account, sufficient to cover the purchased items approximately 20 minutes prior to the purchase. The state will also introduce evidence of the steps taken by investigators to identify purchases of lime made throughout the surrounding area, and their ability to exclude the defendant and his known associates as the purchaser of all but the 2 cash purchases. The timing of the February 26, 2020 purchase in relation to the date that Kayla Montgomery indicates that lime was used on Harmony's body in the Union Street apartment, as well as the work order to snake the drain in the apartment, and Kayla's identification of a bag, which is the same SKU as the one purchased, create a sufficient nexus to the defendant for a finding of relevancy. The challenges that the defendant points out as undermining the nexus of these items with the defendant are all proper fodder for cross-examination. To the extent the defendant seeks to present evidence that the cash withdrawal was for drugs or guns, as he may seek a limiting instruction from the court to avoid this information being used for an improper purpose. Such evidence is relevant to the charges brought in this matter, and there is adequate evidence of a nexus between the purchase of the items and the defendant. Based on the foregoing, the motion to exclude is denied. So another win for the state. So the Home Depot purchases are in. And then the last one here is state's motion in limine to preclude the defendant's use of his own statements. After review and consideration of the state's motion and the defendant's response, the motion is granted. The defendant is not permitted to introduce evidence of his own statements absent a showing of exception to the rule against admission of hearsay or other non-hearsay rule. Again, signed by Judge Amy Messer. All right, and the last one here, the defense team decided to add another witness to their list. Remember, they had 2. Now they have 3. Now comes the defendant, Adam Montgomery, by and through counsel Carolyn C. Smith, Esquire, and James T. Brooks, and hereby gives notice of the following additional person as a possible witness in the above entitled matter. Looks like they're including MPD officer, detective, not sure, Travis Copel. In support of this request, the following is stated. On January 16, 2024, defense counsel supplemented the witness list to include Sergeant Michael Briggerton. This was based upon discovery, indicating that Sergeant Briggerton was the reporting officer of the service call at the Montgomery residence on September 11, 2019. Also, on January 16, 2024, the state provided additional discovery to the defendant. This discovery contained the report of the September 11, 2019 call to the Montgomery residence. A closer look at the report reveals that Officer Travis Copel authored the report regarding the September 11, 2019 call, and apparently Sergeant Briggerton simply forwarded the information to DCYF. So this is the officer that went to the home and did the report. So that's who they're adding to their witness list, it looks like. So again, lots of big things did come out today, Friday, this is January 25th. That last one was out yesterday. But I'm glad we finally have some answers, and I'm definitely glad that we seem to have a lot of wins for the state. Again, that the assault and the murder, the homicide, are going to be in one, which is how it was. And they just tried to throw it out due to that Zwicker letter, and I'm glad the judge was like, yeah, no. So we are, like I said before, we're going onward for justice for little Harmony. I cannot wait for the justice to be had. Unfortunately, we still don't know where the remains of little Harmony are. So at the bottom, and also in the information of this video, I have the new tip line, 603-932-8997. If you have any tips in regards to the Harmony Montgomery case, please call that tip line. They still need any tips that you may have. If you have anything, especially if you might know where her remains were buried, thrown in, whatever awful Adam did to this sweet child. She deserves to rest in peace, and I don't know if she's ever going to get that, but I definitely believe, I really fully believe, and I'm praying that this sweet girl gets justice next month. Alright guys, let me know what you think of all this stuff. It's like I said, we're coming right up, on the heels of this trial starting up. I know CLL, Crime Lines and Lies, will be streaming it, and that's where I'll be pretty much hanging out. So once I get the more deets from Brooks, I will let you guys know on the community tab. So please do come over if you're already not a subscriber over there. And also, if you haven't hit that thumbs up before you leave, please do that on your way out. I really, really, really do appreciate it. And if you haven't subscribed yet also, please hit the subscribe button. I strive here on the channel to try to be one little voice for these victims and for the, getting justice, and whatever I can do in my little corner here. So, all right, guys, I hope you have a great rest of the day. And most of all, stay safe.